Can we just come then to, I didn't get a clear read from you on whether the bill will cover the so-called over-the-top services, so people using Twitter direct messages or the Facebook Messenger app or Gmail. Will the data retention regime capture basic metadata from those services, the sort of stuff that's within the scope of the bill, time of email, maybe data volumes, recipient, that kind of stuff?
I apologise, Senator. I missed the very beginning of that,
so
of that question.
over-the-top services, so not Telstra, not IINet, but Gmail, Twitter direct messages, Facebook messaging clients, other stuff like that. Are you seeking to be able to capture and archive for a period of 2 years basic metadata on those services in the 6 categories that the bill identifies?
So, well, I suppose there's 2 separate questions there. So the 6 categories define what data will be required to be retained in respect of the services that are covered by the obligation.
Yeah.
So I suppose the question of whether those entities are covered comes down to the application provisions rather than the data set itself. The data set itself will apply consistently to whomever is covered by it.
Yep.
And in terms of the entities that are covered by the obligation, those are the provision that those entities that are providing communication services through either carrier service provider or internet service provider, which is operated in Australia. And so in respect of a number of the examples, and I can't recall all of the ones that you named, it would be the case that those would not fall within the obligation. Okay. I think we've addressed some of the particular challenges that both over-the-top and offshore-based providers pose in our submission to the PJCIS, and made a couple of observations there that might be...
So if my email account is an @iinet.net.au address, it will be within scope. And if my email address is an @gmail.com, it'll be out of scope. So all I need to do to avoid mandatory data retention is just to take a webmail service.
I don't know that it's quite as simple as that for the reasons that I set out previously in relation to provision of telecommunication services.
Why is it more complex than that? If I use a cloud hosting provider or GChat or something like that, I won't be caught. If I use an IINet or an Internode address, I will be caught. If it's more complex, please explain how it's more complex.
It's correct that IINet Internode, as a Australian carriage service provider, depending on which part of the entity you're using, it is subject to the obligations. Gmail as itself, or Google as an entity, is not subject to the obligations. So that is in relation to the provision of the email service.
Are you trying to drive people away from Australian service providers?
I think we've articulated the intent of the bill, and the government's articulated the intent of the bill in terms of its coverage.
Is that an unintended consequence that you will be driving people away from Australian service providers?
No, Senator.
It's intended?
I wouldn't frame it in those terms, Senator. I think the government has made it clear that the obligation applies in relation to service providers who maintain their business and their infrastructure here in Australia.
Okay. Okay. We're running over time, so I thank you for your patience. There's been quite a bit of conjecture about the ability of civil litigants to be able to reach these new pools of data, recognising that you're not necessarily changing the way this material is accessed, but you will be changing the volume and types of material that's accessible and potentially how easily it can be accessed. Do you anticipate that civil litigants will be able to, through discovery processes, access the material that will be retained as a consequence of this policy?
So if I could just clarify one aspect of your question, I think you suggested that we would be changing how easily that information could be accessed. The access arrangements are only changing to narrow, not to increase.
To narrow the range of agencies that can get a hold of it. It appears to be a bit open-ended in that other agencies can be added to a list, but set that aside for a moment. Ease of access, by that I meant more that you'll be expecting to be able to access these new categories of data that will exist. It's going to need to be accessible and extractable and used for evidentiary purposes. So I'm assuming that means it may well be easier to access. But even setting that aside, do you anticipate that the material retained under the data retention policy will be accessible in civil matters?
Yep. So I think, as you said, we're not changing the access arrangements, save in respect of changing the number of agencies and prima facie reducing the number of agencies quite substantially from over 80 to around 17. So the access arrangements to data do not change, and so it remains the case that telecommunications data that is stored by communications providers is amenable to a range of lawful process, whether that be a telecommunications data authorisation under the Telecommunications Interception and Access Act, or whether it is in response to another form of compulsion through a discovery process, notice to produce, or such other framework.
Yeah.
It is the case, though, obviously, that any other form of lawful process needs to meet relevant thresholds, whether those be, for example, relevance in the course of discovery and civil proceedings, or notice to produce. There are statutorily prescribed thresholds for access to that data. Those are not being changed through this process.
So it's more the volume of material that would be accessible. So I think that was a reasonably clear answer, so thank you. So, for example, US rights holders trying to track down and prosecute people file sharing, they could access this material under existing processes. It's just that there'd be a lot more material there to look for.
So I think that there's a range of, I don't know that I can answer that in detail in terms of a US entity seeking access to Australian information, etc. But because the access arrangements are not being changed, any access that is available at present in accordance with normal lawful process will continue to be available in respect of retained data.
But what will exist that doesn't exist at the present time is a 2-year record of download volumes, for example.
So what will exist, yes, will be a range of data that is not necessarily retained for that same period at the moment. So some data which is retained for a brief period will now be retained for longer.
That's right, which would be quite useful actually if you're a rights holder trying to find out who's downloading your stuff. I'll leave it there unless either of the other two senators. All right, thank you very much. Thanks very much for your time. Apologies that we went a little over. That was largely my fault. We may put some questions to you on notice, and because I'm not clear of what our reporting date is at the present time, I can't give you a deadline, but the Secretary will be back in touch. I promise it won't be too onerous. Is there anything else that you would like to tell us? Are there any questions you wish that I'd asked?
I don't think I've ever been asked that before. I think I can answer on behalf of all my colleagues to say no.
No,
Thank you, Senator.
Okay. Thanks very much for your time.